Good morning, everyone. It's a beautiful day today here in Great Neck. It's going up to 62 degrees. It's day 497 of the quarantine, and I thought I'd share some great information as I go with you on a walk through the neighborhood. And, it's just an invigorating day right now. All right, so today's topic is, what does it really mean when an attorney yells out the word objection during the course of trial? You want to know the answer? Come join me on this walk through the neighborhood as I share with you that answer. Because you know what? Every single person hears the word objection during a trial. Hi everybody, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so what are we talking about today? We're talking about a scenario where you're watching a trial. A trial, it could be a civil trial, it could be a criminal trial. No matter what type of trial it is, at some point during the trial, someone, one attorney or more, is going to get up from their seat, like an ejection button has been pressed, and yell out, "Objection, Judge!" Why does that happen? Because the attorney wants to alert the judge to something that's going on. Now, for all we know, the judge might be sleeping. Rarely do you find them sleeping, but that's the reality. Something is happening in the middle of the trial, and now one attorney or another decides he's got to tell the judge, "Hey, judge, something's going on here. You've got to pay attention. And you should pay attention to me, and here's why." Now, when an attorney makes an objection, what's he doing really? He's doing a couple things. He's actually interrupting the entire flow of the trial. He's interrupting what the other attorney is doing. Maybe he's in the middle of questioning his witness. Maybe he's questioning an expert. And now, what's he doing? He's interrupting the entire flow. The jury has to stop what's going on, paying attention to the witness, paying attention to the question, and now they have to pay attention to the guy who's interrupting. Now, that could be a good thing. It could be a bad thing. Maybe the jury is so focused on the witness and what they're saying, and now they're listening to this attorney yell out objection, losing their train of thought, and they might be saying, "Why is he objecting? What's the problem here?" And you know what? That is a strategy that some lawyers use during the course of trial, intentionally, to go ahead and disrupt the attorney's flow, to disrupt the pattern, to disrupt what the jury is thinking. Why? Because it does work. It actually works. Now everybody has to divert their attention and deal with the attorney's objection. So what does the judge usually do at that point? What the judge does is he turns around and says, "Counselor, what's your objection?" He wants to know, why are you interrupting? What's the problem here? So now the attorney actually has to give a legal reason as to why he's just interrupted the proceedings. And what happens if he doesn't? If he doesn't, the judge is going to get very annoyed with him and say, "Sit down, counselor, move on." Now, what does that mean? The judge now has to deal with the attorney's objection. Anytime an attorney makes an objection, he's basically saying, "Judge, there's a problem here. Maybe it's a problem with the way the attorney asks the question. Maybe it's a problem with what the attorney is, the topic that he's going to talk about. Maybe there's a problem with something that the witness is about to say." There could be many, many different reasons about what it is that the attorney is objecting to. Now, why does the judge then have to make a ruling, a decision on whether or not the attorney is correct or not? Because for legal purposes, it's critically important that when a lawyer makes an objection, now the judge has to give a legal ruling. He has to decide, okay, is what this lawyer is objecting to, does it have a legal basis? Is it correct? Because if it is, now the judge has to fix it. And if he doesn't fix it, that could be grounds for an appeal if that attorney loses the case and now brings that matter up on appeal later on to say, "Listen, had the judge done these things correctly at that time, I would not have lost this case." So what's going on here is now the judge has to make a decision. And he has to decide, okay, before I go ahead and make a decision, I have to hear what the objection is. And then I have to turn my attention to the other attorney and ask him what he thinks about that. Why does an attorney make an objection? They do it to protect their client's legal rights sometimes. So I say sometimes because ideally that's when it's supposed to happen. But you know something? You will find that some of the best trial lawyers, especially in New York, they may decide not to raise an objection during the course of a trial, during the course of questioning of a witness. Why not? Because they don't want to interrupt the witness. They don't want to go ahead and interrupt the flow of what's going on. The attorney, even though he's maybe bothered by a question, even though he may have a legal right to go ahead and ask, or not ask, but to raise an objection about a question that's being asked or about the way in which it's asked, he may decide, you know what, I'm going to leave it alone. Because the more I interrupt, the more the jury may feel and question, why is this attorney objecting? What's the problem here? Let the guy just finish answering the question. Let him ask the question. Let's get an answer from the witness. An attorney has a choice. If he hears that something is being asked that's improper, he has an obligation to go ahead and stand up and say, Judge, I object. He can't be asking that question that way. That's an improper question. That may be true, and the judge may agree with him. But he may decide, you know what? From a strategic standpoint, I'm not going to stand up and raise the objection. I don't want to interrupt the flow. So yes, this issue is something that I have a right to object about, but I'm not going to because I think it's more important to allow the witness to answer that question because I don't want the jury turning against me because I kept going up and down my chair, jumping up from my chair like a yo-yo every couple of minutes. And the jury will probably turn around and say, I don't understand. Why does this attorney try and block these questions? Why isn't he allowing his witness to go ahead and answer these questions? You have to make a strategic decision as an attorney as to whether or not to object every single time or certain times. Even though you have a right to, even though it's appropriate to do that, you may not want to do that because you don't want to interrupt and you don't want to give the jury the impression that you're trying to prevent your witness from answering something. If the jury senses that the only reason why you are objecting to a line of questioning is to prevent the witness from answering, now the jury could turn against you. And when that happens, now you're at a significant disadvantage. The jury, who may have been favorable to you in the past, now is looking at you, looking as if you've got something to hide. And now you've got a big obstacle to overcome. And if you keep doing that, now the jury's going to keep in the back of their mind saying, I don't understand. This witness had great information to offer. This was a great topic he was being asked questions about. Why wasn't the lawyer letting him answer these questions? So let's go back to the original question that I asked. What does it really mean when an attorney raises the word objection, jumps up out of his seat in the middle of a trial, and stops the entire proceeding just so that this can be dealt with? What it really means is the attorney saying, Judge, hello, stop what you're doing. Pay attention to me right now. Forget about everything that's going on. Now the judge has to look up from whatever he's doing. Maybe he's, doing his bills. Maybe he's paying attention to something else. We don't know. And now he has to pay attention to the lawyer who has just interrupted the entire proceeding and now says, okay, counsel, what's your objection? Now, here's something else you may not know. Lawyers are not permitted to give long speeches about why he's making the objection. So when the judge turns to the lawyer and says, counsel, what's your objection? The lawyer is expected to give a brief, succinct answer to the judge. Many times in the past, this has happened many times, the lawyer will go on a long-winded explanation lasting for a minute or 2 minutes, telling the judge why he believes that the question or the topic is improper. Now, by doing that, he gives the jury a clear sense of why he thinks it's inappropriate to continue. Or maybe there's a piece of evidence that shouldn't be coming in. And now the attorney wants to alert the jury to the fact that something is wrong here. And he does it by giving a long-winded speech. Judges, at least in New York, have done away with the opportunity for an attorney to do that. And if an attorney persists in doing that, you know what will happen? The judge will turn around and start yelling at the attorney who made the objection. Counselor, I asked you for a short, brief reason why you're making this objection. I didn't ask for a speech. I didn't ask for an argument. Just tell me exactly what it is and the brief format. So now, the attorney is going to get yelled at in front of the jury if he doesn't give a short, brief reason. Objection, Your Honor, that's hearsay. Okay, the judge knows what hearsay is. The lawyer knows what hearsay is. The jury may not know. They may have some idea. But that one word, hearsay, gives the judge a clear understanding of exactly why he's objecting. Objection, leading, meaning that the other lawyer is leading the witness, putting words in his mouth, calling only for a yes or no answer. Objection, he's badgering the witness. Okay, again, a short, succinct reason why he's raising an objection. Now, here's something interesting. there are times when the judge will actually decide not to make a decision. Now, that's interesting. The lawyer's made an objection. The lawyer said there's a problem. The judge asked what the problem is. Both lawyers have made short, concise arguments. And instead of raising and making a ruling, the judge says, "Move on, counselor. Ask your next question." Now, what happens then? What happens then is that you move on and you ask your next question. But in almost all instances, almost all, the judge will turn around and actually make a decision. And he's going to say one of two things, actually one of three things. The first thing he may say is objection sustained. Now, what does that mean? When the judge says objection sustained, it means, counselor, I recognize you've just raised an objection. You've interrupted the entire trial. And you know what? I agree with you. That's what it really means. I agree that your objection is appropriate, which means, counselor, you cannot talk about this particular issue. That piece of evidence will not come into play here. That question is inappropriate. So I'm stopping you from continuing what you were doing. That's what it means when the judge says objection sustained. Another alternative would be the opposite, where the judge says objection overruled. And what does that mean? I recognize that you have made an objection to something going on here, and now I'm going to overrule your objection, which means I recognize what you have said. I disagree with you, counselor. The lawyer can go ahead and ask those questions. This piece of evidence will come in. He can go ahead and answer that question. I'm overruling whatever problem you have with this particular line of questioning. So those are two likely possibilities. One of two. Either you cannot continue or you can continue. Now, there's one other option that does happen from time to time. The judge may say, you know what? I can't make a decision right now. I don't have sufficient information or sufficient legal information to help me decide what the proper answer is. In that case, there is the possibility that the judge will turn around and say, you know what? I'm going to reserve my decision. Now, what does that mean? Imagine the Yankees are playing the Mets. And now there's a critical play. 3 men are on base. Somebody hits the ball out, and now it's a foul ball, right? But the runner on third is now coming home, and he scores. But now there's a question. The question as to whether it was really a foul ball or not. And now they all go back to the videotape, and they're analyzing it. And they're trying to figure, the refs are trying to figure out what to do. What they're really doing is that they're reserving their decision until they have all the evidence and they've analyzed every piece of the evidence. The judge does the same thing in this instance. The judge may not have enough information to go ahead and actually make a decision. In which case, he may say, you know what, counselors, I'm going to reserve decision. You go ahead, Mr. Attorney, and continue asking these questions. And at a later date, when I've had a chance to review all the case law, when I've had a chance to analyze the arguments, then I will come back and make an accurate decision. At that point, you guys can deal with whatever issues come up, but I'm not going to make a decision right here and right now. So those are the three options that the judge will typically have when deciding whether or not the attorney's objection is appropriate. So why do I share this quick information with you during this walk around the neighborhood this morning? I share it with you for a couple of reasons. Number one, it's a gorgeous day today here in New York. It's a beautiful opportunity to get out of the house during this quarantine and share some useful information with you as you're learning about how these types of cases work. And now, hopefully, this video will have given you a greater insight into what it really means when an attorney actually yells out, "Objection, Judge!" And now he has to give the judge a particular reason why. You know, as always, if you have questions about your particular matter, and your matter happened here in New York, but you have not yet started a lawsuit, but are thinking of doing so, what I encourage you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, @Oginski-law.com.